back to winning isn't easy. Navigating ERISA disability claims for vascular malformations. Now, if you have disability insurance coverage through your employer or you have it through a plan, it's most likely going to be governed by a federal law called the Employer Retirement Income Security Act, ERISA. Now, there is an exception, and that is if you work for a government agency, state agency, municipality, or you work for a church, potentially your disability policy or plan is governed by state law. It doesn't really matter, I think, whether your policy or plan is governed by ERISA, state law, or you actually have purchased your own individual disability policy, which is also governed by state law. This is a complex area of law, and it's not something that we necessarily learn in law school, by the way. There are very few classes that you can take to learn about ERISA or disability insurance litigation. But there's also the medical side of this. When it comes to vascular malformations, I find that a lot of lawyers and certainly disability insurance carriers or plans don't understand the uniqueness of a vascular malformation type claim. So let's talk about why or what disability carriers or plans don't understand. First, they don't understand that symptoms can fluctuate. You may have worked years with a malformation, and all of a sudden you're claiming that you're disabled and unable to work. Now, they're going to assume that you can keep on going unless you've had a stroke or some major event that's clearly disabling. But many claims, in my experience, will involve a gradual decline, not a sudden trauma. So I want to talk specifically about the 4 ways that a disability carrier plan will deny a claim. So you're thinking backwards. In other words, from the very beginning, you are thinking about why this claim might be denied or benefits might be terminated. So number 1, you've worked before, why not now? They want to know what's changed. Your records need to answer that question very clearly. So your doctor should be documenting how often your symptoms occur, how they've gotten worse, specific tasks that have become more difficult to do or that you can't do at all. And you need to obviously make sure that you are giving and your doctor is recording physical limitations. You might have trouble walking, climbing stairs, using your hands, and you might have cognitive deficits like brain fog or attention problems. This is the kind of case where I recommend keeping a symptoms log, and sometimes even photos or videos can show the real impact of things like seizures or post-stroke motor issues. So think about that as a creative way to document your medical records and to prove up your claim. Number 2, there's no objective proof of your limitations defense. They're going to comb through your medical records and your file, things that you said in your activities of daily living forms, and even calls that you might have with the adjuster for inconsistencies. And if your symptoms don't line up with your medical records, your daily activities, or even, gosh forbid, your social media accounts, that will give them an excuse to deny your claim. Now, a functional capacity evaluation can help. It's a formal test that measures your ability to sit, stand, walk, lift, and do the basic activities of living and work. You want to make sure that you're getting the FCE from a friendly FCE provider, and you want your doctor to review the results and endorse them, because I find that it gives your case more weight. Number 3, your condition is subjective. So we're only going to pay for 2 years. Now, many ERISA policies or plans have subjective medical condition limitations that will cap benefits for 2 years for things like pain, fatigue, sleep problems. And if your symptoms fall in those categories, you want to make sure that your medical team backs up these complaints with objective testing, such as imaging, EEGs, neurological assessments, because we want to establish that there is an objective basis for these quote-unquote subjective complaints. Number 4, depression and anxiety is really the real issue, the reason you can't work. Now, you can imagine that it's common for vascular malformation patients to experience depression and anxiety. But if your policy has a mental nervous policy limitation, the insurer will try to classify the entire package, the entire disability, as psychological in nature so that they can limit the benefits to just 2 years. Now, to avoid this, your doctor has to emphasize that your primary limitations are physical and neurological. Physical symptoms may exist, but they're not the core of your inability to work. Now, one of the things that you do need to understand is that this mental nervous policy limitation comes in 2 flavors. There's your mental or psychological issues are the cause of your disability, or what I call the Monty Python version, which is they are contributing ever so slightly. So what needs to be done here is that your doctor can certainly acknowledge that you have the psychological symptoms, but they have to clearly opine that those symptoms are in fact not contributing to your disability. A final critical point is if your claim is denied, you're only going to have 180 days under an ERISA claim to file an appeal. And the appeal is the trial of your case, and no new evidence can be added. That's unlike a situation where you might have a disability policy or plan through, for example, the city of St. Petersburg, or through the diocese of Pinellas County or St. Petersburg. Those are not generally covered by ERISA. And if there is a denial, you have the right to sue under state law, much like you would have the right to sue if you had purchased an individual disability insurance policy. So the remedy matters, and there are strict time frames that have to be enforced or will be enforced in the context of an ERISA disability claim. In our particular situation, we want to make sure, obviously, that the appeal is filed timely, and that appeal is absolutely solid in terms of the legal reasons why they're wrong, the medical reasons why they're wrong, the vocational reasons why they're wrong. So it takes time to put together a winning appeal, and it's really important that the appeal be done properly, but also timely. Because if you blow that 180-day deadline, you can lose your right to not only appeal, but subsequently to file a lawsuit in federal court. And again, filing a lawsuit is completely different, because in federal court, in an ERISA claim, we are only asking for limited damages, the payment of your benefits, and fees and costs. There are other things like extra contractual damages, bad faith, consequential damages that you can't get in an ERISA case, but that you can get in a state law case. So you can hear in my explanation that what law governs your claim is really important to understand, because the carriers will use that to their advantage in creating these reasons to deny or terminate your benefits. Got it? Let's take a break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos that will assist you in submitting a winning disability application. This is one you don't want to miss. For the next 24 hours, we're giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.